So the next matter on the agenda is the appeal, continuation of the appeal in case number 2018-37. Appeal brought by Gladding Shops LLC, Rocket Real Estate LLC, Federal Properties of Rhode Island Inc., 11 State Street LLC, and New Leaf Realty LLC. Appeal of the Planning Board decision approving a major land development project master plan submitted by 423 Hope Street Redevelopment LLC and SAT Development Partners LLC for the construction of a mixed-use building with 20 residential dwelling units and restaurant use. So this matter, we have had a number of evenings of argument, right? It was one evening. Yeah, one evening of argument presented by the appellant and by the town and the original applicant, I guess appellee in this case. And we at that time set this evening as a time to deliberate and see if we can make a decision with respect to the appeal. Before we get into the actual appeal, there was, since the last time we met, a motion filed by the appellees, a motion to dismiss the appeal of Gladding Shop LLC for its lack of standing to prosecute its appeal and for this Board of Appeals lack of subject matter jurisdiction over the appeal. So that was a motion filed on behalf of 423 Hope Street Redevelopment and SAT Development Partners. There was a response to that, an appellant Gladding Shop LLC's objection to the appellee's motion to dismiss the appeal. So I think before we get into the appeal, I think we should resolve that motion. Mr. Hatton, what do you think about that?
Yeah, I'm happy to have the attorneys address that at this time. And I have a view after reading materials myself. There are two ways we can look at it. We could leave your final decision on that for later. And some of this will depend on whether you're going to send me home to write some stuff up to come back to you with something more substantive. If that's the case, then I may address this in writing rather than verbally. So since it deals with only one party as opposed to all four anyway, and you're still going to have to go through your deliberative process, as far as I'm concerned, unless the attorneys want to argue and leave, I would just as soon just leave it till later for now.
The motion to dismiss.
Correct.
My thought on it, I don't know what the other members of the board feel, my thought on it was it's not on the substance of the appeal with respect to the normal grounds for appeal. This is a matter trying to remove one of the appellants from participating further in the process. I would be inclined to have us make a decision about whether Gladding Shop is in or out.
If that's what you prefer, I'm happy to go that way. That's fine.
That's my thought. So your recommendation is we give attorneys a chance to argue the motion?
I think that's appropriate, yes.
Okay. Well, in that event, it would be, since it's the appellee's motion, it would be 423 and SAT's counsel coming forward.
Thank you, Mr. Chairman. Mr. Chairman, members of the board, good evening. My name is Michael Resnick, and I represent the appellees, the applicant below. As Mr. Chairman just stated, we are here on our motion to dismiss the appeal of Gladding's Shop LLC. The basis for the motion to dismiss is standing and subject matter jurisdiction. Now, while I'll get into those particular arguments in a moment, I'd also like to first address some threshold arguments that were made by my brother in opposition to this motion. So one of the matters that was raised by my brother was that this motion to dismiss is untimely. This position is not supported by a statute, it's not supported by an ordinance, a rule, a regulation, or any case law. This is a fairly bold statement to make without any legal support whatsoever. This motion was filed on November 17th, 2018. That's 11 days before this evening's hearing. So I would submit to this board that it is absolutely proper to consider this motion. With regards to the argument that the motion should not be considered as public comment has closed, this too is not supported by any authority whatsoever. And in fact, I stand here as not a representative of the public, but a representative of a party to this controversy. In addition, even though there is no support for this motion being untimely, it's really a red herring, because the standing analysis and the subject matter jurisdiction analysis in this case essentially rise and fall on one question, and subject matter jurisdiction can be raised at any time, it can never be waived, and it is an indispensable ingredient to any proceeding, whether it's a court, whether it's a board such as yourselves, or whether it's an administrative tribunal. It goes to the very heart of your authority to take an appeal by this party. So I would submit to you that also this issue was raised below. It was raised by Mr. Kelly at the previous hearing, and all we did was provide a memorandum to give legal support for our position to this board, to aid it in its consideration today. And in fact, and please forgive me for being so draconian, but not considering this today and not making a determination as to subject matter jurisdiction is a reversible error in and of itself. So this board must determine whether it has subject matter jurisdiction over Gladding's appeal as a matter of law. There's another threshold issue, and as this board probably knows, normally leases are not recorded in the land evidence record. And so when we submitted this motion to dismiss, I had highlighted 385 High Street as the location that Gladding Shop leases, because Gladding Shop does not own any real property in Bristol. It's a lessee. Now, I stand corrected. It is not 385 High Street. In actuality, it's 205 and 211 Thames Street. But this has absolutely no bearing on the question before this board, because at the end of the day, it's not about the address. It's about the distinction between a lessee and an owner of property, the distinction between a tenant and an owner of property. And the fact that a wrong address was provided has absolutely nothing to do with what's before you. So with regards to our arguments in chief.
Before you go into your argument in chief, Mr. Resnick, you alluded to the recordation of leases as something that maybe the board should take into consideration. Is it the case that Gladding Shop LLC's leasehold interest for 205 and 211 Thames Street is recorded or is not recorded?
My understanding, based on the filing of my brother, is that it is recorded.
It
is recorded. And whether it's recorded has absolutely no bearing on this issue. The reason that I brought it up is that I simply am correcting a mistake. When I wrote the brief, I understood that the property that was being leased was 385. It's not. Fact remains, they do not own any real property in Bristol, which is dispositive of the issue I'm raising right now. And so I had mentioned that subject matter jurisdiction and standing are different doctrines, they're different analyses, but sometimes they rise and fall on the exact same issue. And that's the case here. Because whether or not this board has subject matter jurisdiction to hear an appeal is based on whether or not the appellant is an aggrieved person. And whether the appellant has standing to bring the appeal is also based on the definition of aggrieved party. So what you have here is standing is, does the appellant have an injury in fact? Whereas conversely, subject matter jurisdiction is, does the board have authority? Here it collapses into the same exact issue. And so what we're really here about is, what does aggrieved party mean within the Act? Now, I suggested in my brief that there's only one case in all of Rhode Island jurisprudence that has decided this issue, and that is true. Now, my brother points out and says that I've mischaracterized the law, which I'll get to in a moment. And I'm going to represent to the board that that's not the case. So the only case that's on point here that answers the question of whether a lessee or tenant has statutory standing to prosecute an appeal of a municipal board is GB Donuts of Rhode Island, Inc., v. McCoy, PC 2014-584. And I have copies for the board that I can provide. In GB Donuts, the appellant did not own the property at issue, but was instead a lessee of the property. Accordingly, the question before the court, and I quote, was whether a lessee has sufficient interest in its leased premises to have standing to bring an appeal. In rendering its decision, the court opined, and I quote, the majority of the Rhode Island Supreme Court decisions disfavor an expansion of standing in zoning appeals. In reaching the decision, the court, and I quote, noted, our Supreme Court is generally unwilling to find that a tenant has standing. Highlighted that our Supreme Court is yet to define what interest, if any, a tenant with a current lease must establish to confer standing. Found that the court was not in a position to determine whether tenancy confers standing and whether the nature or length of the tenancy creates a sufficient interest in the property to confer standing, and held that the appellant did not have standing under the current state of Rhode Island law. So Judge Procaccini correctly decided this issue because what he recognized was that the Superior Court is not the place to expand concepts of standing, or by analogy, concepts of subject matter jurisdiction over an appeal. An expansion of law like that should be via the Rhode Island Supreme Court or by way of legislation via our General Assembly. And I want to quote you this very important quote from the judge, and this ends the decision. And I would suggest to the board that it follow this concept because that's what a Superior Court judge held in his decision. And I quote, the court is mindful of the sometimes arduous process of zoning applications and appeals. This court is not convinced that a universal grant of standing to all lessees is appropriate or warranted under the law. Thus, the absence of clear precedent, along with policy implications and potentially significant expansion of standing that would result if the appellant's position is adopted, constrains this court to conclude that the appellant does not have standing under the current state of Rhode Island law. So this board should not consider the length or duration of Gladding's lease. Simply the fact that they are a lessee, they are not the property owner, and under the current state of Rhode Island law, they do not have standing, and this board does not have jurisdiction. Now, as I referenced before, my brother says that I misstated the law. And in doing so, he cites to a case, CCF LLC v. Pimentel, KC-2012-0914. And I have copies of that for the board as well. And this case discusses the issue confronting this board. And it goes on to canvass jurisdictions throughout the United States. And indeed, it acknowledges and discusses cases where under certain circumstances, a lessee or a tenant has been found to have standing to prosecute such an appeal. The issue is that that case is nothing more than dicta. That case was decided on the fact that the appellant did not exhaust his administrative remedies, a completely different theory of law. And so that when we look at case law in any jurisdiction, we look at what was central to the holding. That case has no holding with respect to whether or not a lessee has standing to prosecute an appeal like this. It's dicta, and I will submit that it's completely improper for this board to rely upon it. And that is why I stated to this board that I brought to it the only case on the subject in Rhode Island, and that is as the law stands. Next, in opposition to this motion to dismiss, Gladding outlines the terms of the lease, improvements that have been made to the leased property, what would happen in the event of a condemnation, completely superfluous. This board does not need to review the lease in question. It's very simple. Lessee, property owner. Has nothing to do with the particularity or the length of the lease under Rhode Island's current law. Finally, Gladding attacks this motion as frivolous. Again, with not one single citation to any authority at all. And I take the argument that something's frivolous fairly seriously. And we have the authority, and we have the ability, and we have the right to attack the standing of Gladding and this board's jurisdiction respectfully to keep them in this appeal. And for those reasons, I will submit to this board that for both standing and for both subject matter jurisdiction, this board should grant our motion to dismiss, removing Gladding from the appeal, and proceed to render their decisions on the merits, as is on the agenda tonight. And I'm open to any questions, and I would welcome them.
Mr. Resnick, I do have a question, and it has to do with the definition of aggrieved party.
Sure.
In our ordinance, which allows a person to claim that they're an aggrieved party if they are a person or entity who can demonstrate that their property will be injured by a decision of any officer or agency responsible for administering the regulations and regulations of the town. So, also, any person requiring notice. I'm assuming you're saying, even though they were within the required distance to receive notice, because they were not an owner, they were not entitled to receive notice. Is that correct?
Well, that's an ancillary point.
Well, just trying to figure out this definition because it has two parts to it.
And I would agree with that. I would agree that if you're not an aggrieved person under this reading, you don't have the ability to take an appeal, and there's no entitlement to notice.
I want to focus on notice for a moment, Mr. Resnick. So, presumably, an administrative staff person of the town has to be the one who gives notice of the receipt and pendency of the appeal.
Sure.
And that person would have to figure out who falls within the requisite distance to receive written notice of the pendency of the appeal, or the pendency of the original proceeding before the planning board. Is that right?
That's right. I would note that there's been no argument that Gladding did not receive notice. Gladding was represented by counsel below. They're represented by counsel here. And so respectfully, I'm having trouble understanding how the notice issue pertains to...
Okay, but there's two prongs to the definition of aggrieved person. And I understand your argument that prong number one about property injury, according to your argument, requires that the person be the titled owner of the property as opposed to a leasehold having a leasehold interest in the property.
That's correct.
Okay. But there's an alternative prong for an aggrieved person, which is anyone requiring notice pursuant to this chapter. Okay. And I'm assuming that the notice would have to do with who of record has an interest in the property that might require the giving of notice with respect to prong number two.
Understood.
Okay. So if you acknowledged, at least the argument by Mr. McGillivray, is that the leasehold interest was recorded. Wouldn't the recordation of that leasehold interest give the administrative staff person reason to give notice because that recorded interest affects a property within the requisite distance?
Well, I'd like to take a step back for a moment, and I'm not trying to be evasive, but the fact of the matter is that whether or not Gladding has statutory standing or subject matter jurisdiction is not derived by this ordinance. It's derived by state law. And to the extent that this ordinance is in contradiction to it, it's superseded ultimately.
Well, is there then some statutory reference you want to give me to standing, not the Superior Court, where apparently there is some disagreement between different members of the court with respect to whether a lessee has standing? And I understand you say one is dicta and one is holding, but there appears to be disagreement at the Superior Court. So are you citing us to any statute that says that property means title as opposed to leasehold interest?
Well, and that lies the issue, and that's why you see disagreement, and that's why you see that dicta and you see a decision from Judge Procaccini. There's no statutory definition of the term. If there was a statutory definition of agreed party, this would be a very short motion, or maybe the motion wouldn't be filed, or maybe it wouldn't be contested. My point is that ultimately, it's not just that you have two Superior Court decisions that are looking at this differently. You have Judge Procaccini who said they don't, but they don't have standing. But the reason why he said that is because he found it inappropriate for a Superior Court judge to expand the law in Rhode Island when our Supreme Court has taken great exception to expanding the doctrine of standing. And that's a steadfast ruling. So I would suggest to the board that it's inappropriate for this board to expand this doctrine and to essentially provide standing and jurisdiction to a party that under the current state of the law, I believe that a lessee interest is not sufficient to establish standing. And so I don't know that it's just that we're getting two different decisions by two different courts. You have one court recognizing its place within our court system, its place within our system of appellate review.
Okay. Any other questions from Mr. Resnick?
You know, I'm sorry to interrupt. There's one thing I wanted to add. And thank you. There's just two final points I would like to raise. You could picture the parade of horribles that would occur if a lessee was found to have standing and you have a lessee and a property owner that have inconsistent opinions on a particular project. And I won't go into that in depth, but I think that it's fairly, I feel like it's fairly logical to see that issue, that issue could arise. If you give me one more moment, I just lost my place. Oh. You know, the appellate here, to the extent that this board renders a decision and determines that they are not an agreed party and they don't have standing or that the board doesn't have jurisdiction, they can take an appeal. They have the right to take an appeal. The appeal will go to the Superior Court. And if they get an adverse decision there, it can go to the Supreme Court. And then we can finally have an appropriate case to decide this issue. And it will never be raised in front of a board again because it would be dispositive. But I would suggest to the board that it's not appropriate to expand it here. It's their burden to establish standing. It's their burden to establish subject matter jurisdiction. They have not satisfied that burden. And I would submit to this board that the motion should be granted and that they should be allowed to take whatever appeal they deem worthwhile. And with that, any other questions, I'd be happy to answer.
Anyone else? talk into the microphone, Don.
I'm looking at 28.52 notice of hearing requirements, subparagraph C2. That says, to all owners of real properties located
Can't hear you.
All owners of real property.
whose property is located within 200 feet.
Okay.
Okay. That's the town ordinance.
Okay. Anything else from Mr. Resident? Thank you.
Thank you very much.
Mr. McGilvray?
Evening members of the board, Steve McGilvery for Gladding Shop LLC. Let me just start with the subject matter jurisdiction, because that's the part that I think is frivolous, or most frivolous. Subject matter jurisdiction is really what it says is, do you have the power to consider the subject matter? And no one's denying that you have the power to consider the subject matter here tonight. Really, this comes down to whether one party should be kicked off the list of appellants or not. And if that happens, you still have the power, and you will still consider the subject matter. So really, subject matter is not an issue here. And the question of it can be brought up at any time during the pendency of the appeal is irrelevant. So you have subject matter jurisdiction. No one seems to be really contesting that from a practical standpoint. I'll try to run through these very quickly, but my first argument was really that you shouldn't really be considering the motion at all. This matter's been pending before this board for quite some time. You had a very lengthy hearing last time we were before you. Very generously let us speak at some length. The parties had a great deal of time during that argument and prior to make whatever arguments they want. At the end of that, you closed the public hearing. We had a discussion, a colloquy back and forth about whether Mr. Tights and I even have to show up tonight because you would just be rendering a decision. And then comes this motion. Really at the 11th hour, I was served it the Saturday before Thanksgiving and had to scramble just to get a reply together. So I just think it's out of time. You don't need a case or statute to say that. That's just your own practice. You closed the public hearing. You said pencils down. It should have been pencils down at that point.
Mr. Kelly did raise this on October 30th.
Yeah, he had an opportunity to argue it, and he presumably argued it during the open session, and then you closed the session, and again, it was pencils down, but here we are again. And that's my only point, is that it's another bite of the apple. Now, just going to the law, I think it sounds like the board has a grasp on the case law here. The appellee, the other party points to this case, GB Donuts, and says, oh, that's dispositive. Judge Barcassini said this and he said that, and you guys got to follow it. And if you do anything different than what he says, you're going to be doing something wrong. Just simply not the case. If you look at really the most, pick that up later. If you look at the most important sentence here, Judge Barcassini says, and this is on the last page, he says, as such, he doesn't have a copy of the lease that he's looking at, so he doesn't know what kind of lease it is. And he's saying, well, I've got cases that say if you're a leasehold at sufferance or you have an option to buy, that's not enough of a property interest. And here I don't even have the lease. And so he says, as such, this court is not in a position to determine whether tenancy confers standing and whether the nature or length of the tenancy creates sufficient interest in the property to confer standing. So he punts. He doesn't even decide the issue. We cited to a case where the court said, actually, it looks like the court's come down kind of they look at the lease and they see if the property interest is sufficient. And I would suggest that the two-pronged part of your statute that you were looking at suggests the same thing. Because you have the first part, which says, hey, if you're an owner, if you got title ownership, you get some type of notice if you went to 200 feet. And then there's another category, which has to be different than that, otherwise they wouldn't have a separate category, of aggrieved parties who can just show some type of injury to some type of property interest. And the cases seem to suggest that if you're a leasehold of sufficient length, if you pay taxes, if you have an interest in the property of sufficient nature, you're aggrieved. If there's something going on that affects you adversely. And that's the case here. We got a 65-year lease. It's a true net lease. The Gladding Shops pays the taxes. They have to make improvements to the property. They pay insurance on the property. I mean, for all intents and purposes, for the 65 years, they own the property. They're virtually no different than any other property owner for the term of 65 years. And I would suggest that is sufficient property interest for a person to be aggrieved if something in their neighborhood happened that affects the neighborhood. And that's pretty clearly what the cases say. And now, I'll just end kind of with a practical concern. Two things. One, in the record itself, there's a note that says that gladding should be added to the abutter list. I don't have it with me, but it's under the public info postcard section. And I haven't looked at it recently, but it's a note from Diane Williamson to Susan, and it says that they should be added. There's another aspect of this that Ben Bergenholt was told that because his parents, who were the principals of Gladding Shops, owned a business in close proximity, that he should recuse himself from, he was a member of the HDC. So Gladding Shops really has been treated by the town as a property owner. Finally, I would just say, dismissal, our courts say dismissal of someone's cause of action, appeal, is a very dramatic and drastic remedy. That's a pretty consistent theme through all types of actions to dismiss in various courts. And so what's being asked of you is fairly dramatic and drastic. And I don't think you should do it unless you have clear law telling you that you should. And here that's just simply not the case. It looks like the Superior Court, if anything, is a little confused on the issue. And then secondly, I would just say, as a practical matter, you're not going to do anything. The case doesn't go away. All you're going to do is create another issue for Gladding Shops. Now, Gladding Shops has another thing to complain about. Hey, they dismissed my cause of action. They dismissed my appeal. They shouldn't have done that. Related to that, it's going to result in piecemeal litigation because Gladding Shops will be able to appeal that decision immediately. Whereas if you hold, if you remand or reverse, that issue might not be appealed for some time. So you're going to create piecemeal litigation. As a practical standpoint, courts tend to try to keep issues together because it creates what they call judicial economy. So you keep all the parties together. You let the Superior Court, if it ever eventually goes to the Superior Court, figure it out as to all of the parties. And the Superior Court can decide then, hey, should Gladding have been a party? They shouldn't have been a party. Will it have any effect on the ultimate resolution? No. But you argue the motion. And I think it should be denied. You should just keep them all as parties. You shouldn't take some type of drastic step with respect to Gladding Shops unless there's really clear authority that indicates that you should go in that direction. I'll take questions too if you have any.
I do have a question about what Mr. Kern brought up, which is the second prong of the definition in our ordinance of an aggrieved party as being anyone requiring notice pursuant to the chapter. And then Don referred us to 2852C2 with regard to whom written notice of public hearings is to be sent. And that does specifically say owners of real property.
Right.
So you're not relying on that to give that particular portion of definition of agreed party, because they weren't required to receive notice pursuant to our notice requirement.
Yeah, I think, you know, the town has treated them as the owner, but I'm not proceeding under that.
Okay, so you're proceeding then under the first prong,
Yeah.
which is they have a property interest that would be injured or potentially injured by a decision of an officer or agency responsible for administering the regulation.
That's correct. And my point was a pretty basic one. I think the movement to the appellee here says, well, you have to be an owner. Well, yes, that's true under the first prong. But the second prong extends it to anybody who can show an injury to property interest. And a 65-year lease where you pay taxes and you maintain the building is a sufficient property ownership, level of ownership to give you standing.
Any questions for Mr. McGillicuddy? No. Thank you.
You said that there are
Can't hear you.
cases.
We can't hear you.
You indicated, Mr. McGilvery, that there are cases that indicate that an aggrieved party, I don't want to misconstrue what you said, so I'm trying to understand what you said. You first said that we don't have to follow Judge Procaccini. And the question really resolves down to if there's a sufficient interest, then they're an aggrieved party. What case says that?
Okay, well, that's the case, I don't know if you got a chance to read our...
CCF?
Yeah, CF and all the cases that are cited in CF and other jurisdictions. My point
I'm
was...
talking about Rhode Island cases. Is it
Yeah.
CCF that you're talking about?
CF, yes, that's the one that talks about it. And then also, I'm not saying he shouldn't follow Judge Procaccini. He doesn't say what they say he says. He says, I don't have the lease. If you look at that case, he doesn't have the lease.
Well, doesn't Judge Procaccini say, even if GB Donuts is not a tenant in sufferance, which for sure knocks you out of the box, our Supreme Court has yet to define what interest, if any, a tenant with a current lease must establish to confer standing. Aren't you asking this board to predict what the Supreme Court would do when faced with this situation that it has not yet done, that it has not yet created such an interest?
No, Mr.
And you're asking this board to create that here?
I appreciate you trying to argue for one side, Mr. Hayden, but that's not what
I object to that comment. I'm
Okay, you
directing my comment to your argument, and I directly quoted Judge Procaccini's case. And I'm trying to understand why what support you have for your proposition where you say that any lease other than a tenant in sufferance may have a sufficient interest.
If the board wants me to answer that question, I just don't know if a continued colloquy between attorneys is helpful, but if the board wants me to continue on, I will.
I would say answer the question, and then we're going to get into a discussion amongst ourselves to rule on this.
So I think what I said to the board was pretty clear, is that it's unclear. The Superior Court judges don't seem to know what they're writing. But at least one says, Procaccini says, I don't have the lease, so I can't say anything. The other person says, it looks like other courts look at what type of interest you have here. And you have to look at the lease and look at what kind of interest. So I said, if you follow that line of thinking, then this is the type of lease that would give you the type of property interest where you're agreed. But I also made the separate point that because it's unclear, you shouldn't take the dramatic and drastic remedy of dismissing a party from an appeal. Keep them all together. It's going to get sorted out one way or another. Don't create another appeal issue for one party. Let it proceed together in the interest of judicial economy. So that's my point.
If I may, trying to understand your argument, are you saying that should the Supreme Court be confronted with this situation, you believe that the kind of lease that your client has would be sufficient for the Supreme Court to determine that they have standing as an agreed party?
going to leave it to the board. If you'd like me to continue answering the questions and find it helpful, I will do so. But I think I made my point
I
pretty
think it
clear.
would be helpful to understand your argument about the nature of the lease that Gladding Shops has and why we should regard that as a sufficient property interest.
Certainly. There is a line of cases that is pointed that is referenced in the CF case. And it says that if certain types of leases, long-term leases in particular, will give a party sufficient property interest to determine that they're aggrieved. Now, the lease with Gladding is a 65-year lease.
So is a 65-year lease financeable? Is that something that you can get financing for?
That's a good, it's beyond
Tony, my banker man, is a
Yes.
65-year lease something that you get financing? I know a 99-year lease, typically you can get financing for a 99-year lease.
Not to quote any particular credit policy that's it's even remotely close to statute, but I would say that in the event of a 65-year lease, it has been my experience that financing for leasehold improvements, given the amount of time of the lease and the amortization of whatever financing, that a 65-year lease would not, by any stretch of the imagination, be considered ownership, but it would be considered, to some effect, that the lessee has significant interest in the property, in the contract in itself. Again, strictly for leasehold improvements, would, it would have some bearing on a credit decision.
So would a lender then require the leasehold interest to be assigned as collateral for that loan?
No, because the leasehold, the lease in itself is worthless. We take an assignment of the lease if the property owner themselves were willing to participate in the guarantee of the transaction. But without the property holder participating in the transaction, then any assignment of lease wouldn't exist, strictly with the lessee.
Okay, thank you.
So I would just add, with respect to this lease, that there are other indicia of ownership. The lessee is required to pay utilities, the operating expenses, repairs, maintenance, improvements. They're required to supply liability insurance, flood insurance, fire insurance. Under the lease, they have to make certain improvements, physical improvements to the property. And also the lease provides that in the event that the property is taken by eminent domain or condemnation, that the lessee should share in the award. So it really is, if you're looking at a spectrum of leasehold interest from the leasehold at sufferance, which is virtually more like a license than a lease, and then this type of lease, this is way out on the other end of the spectrum, much closer to fee ownership over a period of years.
Thank you.
Yes, for the record, Andrew Tights, T as in Thomas, EITZ, representing the appealee of the Bristol Planning Board. I just want a couple of quick things. One is the language in the Bristol zoning ordinance, the two-prong test for standing, which includes the notice language, is actually the same as the state language in the Rhode Island general laws. So just for that. Second of all, I do want to point out, it is the position of the appellee, even though this is an appellant, and I suppose I should be happy that an appellant might be struck for procedural reasons, but to be consistent, it is our position that this leasehold interest did confer a property interest sufficient enough to provide standing, certainly to participate in all the hearings, if there was that sufficient property interest. Mr. Kogan, you hit on one of the things that was involved, in fact, the very reason for this 65-year length was because that was what the tenants required so that they would have a financeable interest. So that is our position on that. And it is in fact true that I did indicate that Ben Birkenholtz, who is the son of the members of the LLC, would have a conflict if he served on the planning board, on the Historic District Commission when they were hearing it. I know we've got the planning board appeal now, but I do want to confirm that fact. Thank you. Sorry, any questions?
No.
Sure.
I may have misheard Mr. Resnick earlier. I thought he said that the issue was raised below, and maybe he meant before, i.e. verbally by Mr. Kelly last hearing. Was it raised below in the prior proceeding?
Not, I can't say for sure, but not to my recollection. You mean at the planning board or at the Historic District
Correct.
Commission?
Right.
I do not believe it was raised.
Okay. I made that straight up.
If I could just make it very brief.
Sure.
Thank you, and I mean brief. I just want to quote basically the last line of the GB Donuts decision. Appellant does not have standing under the current state of Rhode Island law. To suggest to this board that Judge Procaccini punted the issue is a joke. Let me read to you what Judge Nugent had to say. In the only case in Rhode Island that the appellees are relying upon. Ultimately, for the purposes
You're
of...
only relying on one case as well, Mr. Resnick.
That's right. Well, my case has a holding, and Judge Nugent's is dicta. Ultimately, for purposes of this decision, this court will assume, without deciding, that CCF is an aggrieved party with standing to appeal.
Mr. Resnick, could you provide me with the page that you're looking at?
Yeah, absolutely.
You're in CCF right now?
Yes, it's page 5, and if you're using Westlaw, it's 2013 WL 2393044. It's a 2013 decision.
What is the wording at the beginning of the relevant paragraph?
CCF alleges that the construction and operation of the McDonald's drive-through restaurant will adversely impact it because the new restaurant will create traffic problems on New London Turnpike. And Judge Nugent proceeds, and then he ultimately says, for the purposes of this decision, this court will assume, without deciding, that CCF is an aggrieved party with standing to appeal the planning board's decision. So that's not a holding. It's not central to the decision, and I would submit to this board that it's completely extraneous. This decision is about exhaustion of administrative remedies. It just does not stand for the proposition that the appellants are stating that it does. And I understand that Judge Nugent canvassed the case law in a myriad of jurisdictions. I would submit to this board that Rhode Island law is different in many respects to many different states on many different issues, especially those of a municipal character. And so we really should be looking at Rhode Island case law here. And we should not be relying on a decision that does not hold or support the position that's being proffered. Just one final comment, and I'm going to quote to a treatise that is very well respected in the area of zoning and planning. It's Amger 2nd Zoning and Planning, section 631. It's noted in my brief, and I quote, "The issue of local zoning board of appeals, subject matter jurisdiction, is a question of law that must be ascertained from an interpretation of statutes and local ordinances." So this isn't about what's right. It's not about making more appealable issues. It's not about when the pen or pencil dropped. It's about what the statute says and what a fair construction of it is and what courts in this state have decided. And unfortunately, we only have one. And that judge knew that it was inappropriate for him to expand these doctrines, that the place for it is the Rhode Island Supreme Court. Thank you.
So we have to decide this motion to dismiss as to whether or not Gladding Shop LLC has sufficient standing as in order to prosecute their portion of the appeal.
Mr. Chairman,
Yeah.
before we make the decision, can I ask for a short recess? Sure. For 5 minutes? I already apologize that I appeared late.
So we're going to take a recess for 5 minutes.
Thank you.
So we have to decide this motion filed to dismiss the appeal of Gladding Shop LLC. I'm not sure that it's significantly consequential whichever way we decide this, because as was indicated by all of the lawyers, the case has to continue on for the other parties in any event. So I'm not sure it makes all that much difference, and it may in fact create some separate set of issues. But in terms of looking at the definition of aggrieved person, which is our ordinance's standard for who can bring an appeal, I don't believe that Gladding Shop was required to receive notice, as Mr. Kern pointed out, under 2852C2, because they are definitely not the owner of real property. They do have a property interest in the premises at 205-211 Thames Street as the holder of a 65-year lease. And that is a very substantial property interest. And because our ordinance, and Mr. Tights pointed out, the Zoning Enabling Act, using the same language, doesn't say they have to demonstrate that their property ownership will be injured by a decision. I take that to mean substantial property interest being injured, and a 65-year leasehold interest is a very substantial property interest, which I think would give Gladding Shop Limited, or LLC, sufficient standing to prosecute their appeal, along with the 5 other appellants. So I think the motion to dismiss the appeal should be denied. Charlie?
I would agree. I think the town has entered into a partnership with Gladding, and as Mr. Tice was nice enough to point out, the intent was to grant them an interest, and I think holding a motion would cause them potentially a large amount of damage, and I would be prepared to dismiss the motion as
Anybody else want to say anything? I'm going to make a motion for us, for the board, that we vote to deny the motion to dismiss that was filed by SAT Development Partners and 423 Hope Street with respect to Gladding Shop LLC's right to participate in this appeal. Is there a second?
I'll second.
All in favor?
Aye.
Aye. So the motion is denied. So now we have to move on to making a decision about the appeal that has been filed in this case. Find the appeal document. My thought on this, and I'm certainly open to suggestion from counsel, our counsel, Mr. Haddon, is that we should go through the points raised in the application for appeal and discuss each of the points that they claim would be sufficient basis for us to reverse or take action with regard to the appeal. What do you think about that, Mr. Haddon?
That's fine.
So turning to the application for appeal that was filed on behalf of the various appellants. The first set of grounds for appeal starts on page 3. And this relates to one of the bases on which this board, sitting as the Board of Appeals, could reverse the decision of the planning board. And that set of grounds would be, at least the allegation in this appeal, that there was prejudicial procedural error. That's one of the bases on which we could reverse. So the first point raised that is alleged to be grounds for reversal would be proper notice was not provided pursuant to Article 8, Procedures of the Planning Board, Section 8.5, Gladding Shops LLC, Rocket Real Estate, New Leaf Realty, Federal Properties, Rhode Island did not receive proper required notices to several meetings in violation of this section. Anybody's take on that, Charlie?
I didn't see any prejudicial issue with that. I saw the list of abutters. It was comprehensive, so I'd like more information if there is something was left on the list and it impacted the decision. I didn't see any.
Right, and we didn't receive any specific argument about what was defective about notices. And it certainly appears that the parties had the opportunity to participate in the planning board proceedings and did, in fact, participate extensively in the planning board proceedings. So my take on this is if there was any impropriety with regard to required notices, it wouldn't amount to prejudicial procedural error. Anybody have anything else they want to say about that? Do we have to vote on each and every one of these, Mr. Haddon, or what's your recommendation about how we handle this procedure? I mean, I'm prepared to have us discuss every point of appeal to see what the board's take on it is. So should we be voting on them individually? Why not? Okay. So then, I'm going to make a motion that
Either that or assess at some point to make sure that they're keeping the score. And
We can't hear
one
you.
entire decision, but you've been voting on it.
Can't hear you. We can't hear you.
Just use the mic.
Either that or you wait till the end and we try to record in writing, or if necessary, if I'm sent back to do some penmanship to return it to the board. I'm not sure what your pleasure is on
I
that.
think
Then you have an entire decision that you then vote on as one.
okay. I'm not suggesting that whatever we're voting on is the written decision. It's just how we are making decisions. And I think it would be clearer if we vote on each of these alleged grounds for appeal.
That's fine. Are you saying like taking a straw vote right now, so that's...
Right. I don't know what we need a motion, we just need a vote.
The vote. Okay, so the vote, the question then would be, do we deny this ground for appeal? That's probably the way to make the motion, is do we deny this ground for appeal? That it does not amount to prejudicial procedural error. Number 1A in the reasons for appeal. So all those who believe it does not amount to sufficient prejudicial procedural error say aye.
Aye.
Any nays? No nays. Next point is the town solicitor improperly advised certain members of the planning board that they must recuse themselves without adequate basis in law, resulting in prejudice to the aggrieved parties, including the appellants. So there were, I believe, 2 members of the planning board who did recuse themselves in this matter. And certainly, the record indicates, and there was argument that there was discussion between Mr. Tights and some members of the planning board about their potential recusal. So the question is, does that amount to prejudicial procedural error? That there was advice from the town solicitor given to certain members. Don, David?
I agree the way it was, they should have recused themselves, which they did. Because he mentioned it, that's his job to mention it, that they did wrong and they should excuse themselves from taking part in the meeting, whatever. So I agree with that.
So your view is it was not an error for the town solicitor to give advice to certain members about their potential recusal? Okay. Charlie, did you want to say something?
I agree with the 2 recusals of the alternates was appropriate. I believe that. I believe that the vice chair actually provided his opinion before hearing all of the testimony, which in our environment would not be appropriate, but I'm kind of on the fence about that because I wasn't there. And Mr. Prince did explain how that came about, and he was counsel and made the decision not to recuse, so I'm okay with that too.
I think one of the other recusals had to do with somebody having some connection with financial interest. Isn't that the other one?
It was, I know what that is. Like I said, I think both of those were appropriate.
I do believe Mr. Katz wanted to recuse himself because he had an interest in speaking before the board as a citizen rather than as a board member.
All right, so in any event, the fact that the solicitor gave people advice about recusal would not be unusual. So I'm going to make a motion that we deny the ground identified in reasons for appeal, paragraph 1B, as amounting to prejudicial procedural error.
And I would suggest that you make a finding regarding was there any prejudice shown by them.
Okay. So it doesn't, for the reason that it does not appear there was any prejudice arising from the receipt by those members of advice from the town solicitor, and the board was able, the planning board was able to continue with the proceedings and render a decision after a significant investment of time and discussion on the record. I'm going to make a motion that we deny ground 1B as amounting to prejudicial procedural error. All those, is there a second?
Second.
All those in favor of denying that ground for appeal say aye. Aye. Any nays? So ground 1B is denied as basis for appeal. Ground alleged in 1C that the joint HDC planning board meeting violated fact-finding requirements and resulted in deal-making rather than enforcement of existing law in violation of, inter alia, Article 8, Procedures of Planning Board, Section 8.6. Numerous errors of procedure were committed throughout the meeting as the Planning Board and the Historic District Commission members exercised improper influence upon each other, all in an effort to, quote, make it easier for us to make a decision. This resulted in confusion regarding applicable standards that each body was to apply. The appeal goes on with lots of examples, but that's the basis for this particular assignment of error, that the joint meeting was prejudicial procedural error because mixed up standards and resulted in confusion.
I would also suggest, if I can, Mr. Chair, continuing to review the rest of that, because it discusses the issue relating to the sending out of a decision with a flat roof, etc., that did become part of the argument quite a bit last time. So
Right.
I suggest that
So
that be
presumably,
reviewed.
right, so although I think that's slightly different than the joint meeting, I think that's a different point. You know, the point that there were draft decisions doesn't really, that could have been the case even if it was a separate meeting.
I agree. If you want to deal with that, part A, part B, that's fine.
Now, there is a separate point of appeal, but I think that particular area is more germane to paragraph 1E with regard to the drafting of findings, so I think I'm going to hold off on that and just focus on the fact that there was a joint meeting about which we heard much argument that there's no authority for it, that it's common practice. We heard lots of argument back and forth on the fact that there was a joint meeting and that as a result of the joint meeting, there was opportunity for members of one board to influence the other board, and that the standards got mixed up. So that's this point of appeal, that we have to decide whether that was an error, and if it was an error, was it a prejudicial procedure?
Mr. Chairman, before we proceed, this is a very lengthy paragraph.
It is.
And the balance of the paragraph is specific to some of the procedures that are followed. So I would prefer not to lose sight of that when we're going to leave this. I think they're two separate issues, which is the joint meeting, but then also how they came to the decision on the flat roof versus the pitch. So,
Well, okay. I think we should discuss them together because the appellant has lumped them together in a single point for appeal, so I think we can discuss them both and decide the jointness of it and then the deliberations resulting in alleged influence of one word over another. So, what about the question of joint meetings of two boards? Don, you look like you have something to think about.
If that's all we're considering, I think both sides are clear, and I can make a decision. I can make a decision on whether jointness was appropriate or not appropriate.
And just, could you share your thinking with me?
I think it was appropriate.
I mean, yeah, Dave?
The joint meeting, I mean, it's allowable by law, and when you get a joint meeting, you'll have different ideas come about, and a lot of some of the ideas that you had, like, for instance, the flat roof, it doesn't look that good, especially in a colonial historic building. It should be, because the flat roof reminds me of a factory. I mean, you see some of the mills downtown, all flat roofs, and I think the pitch adds a little more style to it. So I don't think there was any influence there. It just, he picked up a point and thought, maybe you're right. Maybe so, going with the pitched roof is going to be more appropriate for the area than the flat roof.
I don't have an issue, and I've said that before. I didn't have an issue with the joint meetings. I think it was sufficient. In retrospect, and I don't want to be one to report that, the deliberations based on the record appeared to be very confusing when we had the zoning board and the HDC trying to decide. Planning board, I'm sorry, planning board and the HDC trying to determine what each board was doing. It seemed very confusing to me. So I don't know if that means it was tradition error, but it certainly did create an environment that I thought was confusing for members to have.
So my take on it is that there were notices notices went out that were separate notices. They convened together. Ultimately, they voted separately on motions that ultimately was initially a straw vote and then became the final vote. I think the notion that it might be more efficient for town staff, lawyers, parties holding a joint meeting doesn't seem like it's a prejudicial procedural error to make that decision. If it were prejudicial procedural error, then presumably somebody who felt it was a prejudicial procedural error should have raised that ab initio in order to force the board into those boards into separating. Because I know when we received these two appeals, we made the decision it would be easier for us and less confusing if we worked on them one at a time as opposed to consolidating them for appeal. But I think if anybody, any of the parties or any of their lawyers thought that it was going to be prejudicial procedural error, we should have raised that at the beginning. And it may be that it doesn't turn out the way you thought it was going to turn out, and that something happens that does cause it to be an error that prejudices somebody. But I don't think as a general statement you can say that having a joint meeting amounts to procedural error, much less prejudicial procedural error. So then the question would be this more detailed allegation of error about what I think somebody during the arguments, or one of the briefs says it amounted to bait and switch, that parties believed all they were dealing with was the flat roof submission, because it was the latter submission, and then the record got closed, and then the two boards, the board and the commission, then wound up discussing both of the submissions, the pitched roof or peaked roof submission and the flat roof, that somehow that converts it into prejudicial procedural error, the fact that there were two options. Well, those options were publicized, were presented, they were part of the record, and I think the second option was generated because one of the boards wanted a second option generated. So the fact that they were both in the record and then the boards eventually coalesced around one particular design, there was lots of opportunity for people to complain about the height, which they did complain about the height, and the massing of the buildings. And I don't know that it would have been any different if there had been two separate proceedings and there were options that were presented, and the board and the commission had to decide which one they separately approved of. So I just don't see this as amounting to prejudicial procedural error. I'm going to make a motion that the assignment of error in paragraph 1C about the joint meeting of the Historic District Commission and the Planning Board amounting to prejudicial procedural error, and the specific assignment of the proposal switching from one type of a design to another type of a design when both designs were part of the record, and therefore either board to approve of does not amount to prejudicial procedural error, and I would move that we deny that assignment of error. Is there a second? All those in favor of denying assignment of error 1C, say aye. Any nays? That assignment of error is denied. The next one is in 1D, planning board failed to address the required factual findings as required by Article 8 Procedures of the Planning Board, Section 8.6. Rather, the planning board simply accepted pre-drafted findings that it neither addressed nor meaningfully discussed. So, let's anyone's pleasure on that one. I think, this is, I think, Charlie, going to your concern about the deliberations on June 20 and the June 21st hearing.
21st and how it transformed into the July 12 meeting. And that's an issue that I have another issue that we'll get into. It's at the end of this one.
Yeah, I think we'll get to that one eventually.
We can't hear you. Please talk into the mic.
You're talking about the comprehensive plan.
So I'm more concerned about the decision of the straw man vote that was made on the June meeting.
Is your mic on?
Put it closer to your mouth.
No.
Move it.
Pull it closer to you.
I said I was more concerned about the June 21st straw man vote and how that transformed into the activity in July 12th.
So presumably, boards are supposed to make factual findings to support their determinations. In fact, they're required to do that. The transcript of the June 21st hearing has some conversation, although it's not separated out by board. They seem to intermingle their discussion, but has some discussion about the aspects of the proposals. Perhaps way too much of that discussion focused on height of the designs and the flat roof versus the peak roof, pitched roof design, when there were potentially other aspects that the findings could have addressed. And it is clear that eventually, based on the straw vote, the solicitor did prepare draft decisions, alternative draft decisions for the board that did include findings. So I'm not sure how much has to be on the record in discussion, because they did have the opportunity on July 12th and had received those draft decisions in advance, although not far in advance, but apparently in advance of the July 12th meeting, and had an opportunity to see Mr. Teitz's take on what the boards had been discussing as support for conclusions with respect to either a pitched or a flat roof. They had the opportunity to review that, and they voted to, a majority voted to adopt those findings as their findings. So the decisions have factual findings. And the board had the opportunity to review those. They had heard argument. They had received lots of evidence and testimony and expert opinions and lawyer participation about all aspects of the proposals. So now I'm wondering, are we to say they had to, on the record, discuss each and every point, that ultimately they gave a cue to their solicitor to help them draft a decision, and if it wasn't in the transcript, that somehow that was a failure on their part? I think there were findings of fact in the decisions that they voted to adopt.
Can we hold this just to whether or not there were findings? Because I think more of it's what you just said is in paragraph E,
In paragraph E.
whether or not we have a,
So then you're asking us, Mr. Kern, to look at the decision itself. You know, for example, if we look at the decision itself, starting on page 3 of the decision of the planning board and running then over to page 5, there certainly are what appear to be findings. And do you believe, Mr. Kern, that those findings
are meaningful and will appropriate discuss?
Yeah. That meaningful and appropriate to be discussed, I think is what Mr. Kern said.
So, I vote with E to deny.
Mr. Kern, any thought on that?
Can't hear you.
Would you get closer to the mic?
Just all take one. No, I'm in agreement.
In agreement that the written decision did address required factual findings, meaningfully and appropriately. Mr. Kern, so anything else on that?
I would agree with the written decision for the straw man vote on the flat roof reflected the findings of fact.
Okay. All right.
So if it's for both, probably we'll uphold. But I think it'll get covered at E.
Okay. So then I'm going to make a motion that we deny the assignment of error in paragraph 1D, that in fact the planning board did address required factual findings in its written decision, findings that would have been required by Article 8 of the procedures of the planning board, and as Mr. Kern suggested, they did that in a meaningful and appropriate way. So that's my motion. All those in favor of denying the assignment of error in paragraph 1D, say aye. Aye. Anybody opposed? That assignment of error is denied. And the assignment of error in 1E has to do with the town solicitor. This is the assignment of error. Town solicitor drafted findings for inclusion in his July 12, 2018 planning board decision, which were not addressed or discussed by the planning board. Moreover, in many respects, these findings constituted the town solicitor's apparent attempt to have the planning board accept a version of the project that it had flatly rejected in the previous meeting. For instance, at the June 21, 2018 meeting, the planning board voted to accept a building height of 41 feet with additional height that includes elevator and storage units on the roof, bringing the total height to 51 feet 6 inches, or 15 feet 6 inches higher than the maximum allowable height. Prior to the next meeting, the town solicitor drafted findings of fact that directly contradicted this. These findings stated that the planning board had been persuaded by the HDC that the pitched roof design was more consistent with a mercantile building. If the planning board was somehow persuaded between the end of the meeting on June 21, 2018 and reconvening on July 12, 2018, it's in clear violation of the Rhode Island's Open Meetings Act. So that's the assignment of error in paragraph 1E, that town solicitor taking cues from the straw vote and then preparing two different draft decisions for the planning board, which ultimately approved the pitched roof design when the straw vote had focused on the flat roof design was error, and that it may have been in violation of the Open Meetings Act if there was some additional meeting or convening between June 21st and 2018 and July 12th. There's nothing in the record about the board reconvening. I don't believe we have any reason to believe they did reconvene. So, and I know Mr. Kelly made a big deal about how the Open Meetings Act, was not our territory, but, there was nothing in this record that indicates that the board somehow had a secret meeting and had secret discussions. The discussions that the board had, both on June 21 and July 12, were in fact confused to a certain extent, as Mr. Burke has pointed out, and they could have been clearer. But we did hear an explanation from Mr. Tights that the vote was close at the June 21st meeting, that that he felt it wise to prepare two different decisions, that the board could choose between which one it wanted, flat roof and peaked or pitched roof, and that then the board had a discussion on July 12th, and at least one member of the board changed his mind or her mind to vote the other way. So, I think there had been plenty in the record, plenty of discussion in the record about the height issue and the two different styles of roof. Those issues were before both boards, and I'm not sure that there was anything procedurally wrong with Mr. Tights attempting to have two different decisions prepared. I wonder why he didn't do that for Historic District Commission as well, because we were told we only did one for Historic District Commission and two for the Planning Board, when in fact that was a split vote as well, a 4-3 vote on for that board. But this is only the Planning Board appeal, and the fact that he prepared two different decisions because the board might have changed its mind. And there was a time crunch. It was, if they didn't make a decision by July 12th, if they didn't render a decision by July 12th, their opportunity to deny what would have lapsed. So I don't know that it was unwise for Mr. Tights to prepare two different decisions and have them available in the event that one or more members of the board shifted when they had the opportunity to have a further decision. It was a straw vote. It was not a formal final vote. It was a straw vote. So having two different decisions, to me, is not procedural error, and certainly not prejudicial procedural error. But is the record thin on their reasoning for switching? Yeah.
I don't think it's that thing.
Okay.
On June 21st, I think we all acknowledged, and we read all of the testimony that Louis wrote. And the motion was made to approve the flat roof design, specifically because of the height concerns. And the solicitor was directed to draft a decision for the flat roof. That's also apparent from the evidence, and it wasn't for the peak roof. The issue of the discrepancy between the planning board and the HDC decision was discussed, and people realized that they were voting for separate plans at that time. A motion to reconsider by the planning board did not pass, so they made a motion to reconsider the decision to approve the flat roof. Didn't pass.
On June 21st.
On June 21st. The process to resolve the discrepancy was discussed, and it was to appeal one of both decisions to the Zoning Board of Appeals, or to reconcile the plan with either the HDC or the Planning Board. That's what's in the record. There was additional discussion about the impact of members changing from a vote to the straw man vote and the writing of the decision. The discussion was about changing approvals or denials, not about changing the plan. The solicitor wrote the two plans, but in the context of open meetings, I don't know how he had the authority to do that because the planning board, based on the vote, didn't ask him to do it. So, and additionally, my interpretation of the procedure is that if you make a motion to reconsider, it can only be made once. So they made the motion to reconsider that vote on the 21st, and then they made an identical motion on the 12th. And I don't, because it doesn't make any sense, you could just keep making the motion to reconsider until you got the vote that you would like. So I believe that procedurally was incorrect.
Was it prejudicial?
Well, in the context of there being a high concern, and the fact that they changed the vote, and the building is now some number of feet higher than 7 or 8, I don't know what it is. Yes, I think so.
But they did denominate what they were doing as a straw vote, and that they wanted to see the written decision that the solicitor was directed, because that's what the vote was on. The vote was not on the question of, are we approving or disapproving? The vote was on, should we direct the solicitor to prepare a decision for us to review at our next meeting? That was the specific motion. It was about directing. Yeah, for the flat, yes, for the flat roof. But it wasn't a vote, it wasn't characterized as the final vote on what are we approving or not approving. It was a vote to direct the solicitor to prepare a draft decision for a flat roof, correct. But in terms of open meetings, there's nothing in the record that suggests that members of the board met with the solicitor between June 21st and July 12th.
I wasn't saying that. I wasn't saying that at all.
Yes, I mean, open meetings, let's put that to the side. I don't think this is an open meetings question. Okay, well, you did bring that. That's, so that's why I'm responding to that. So you're, again, what I'm taking from your comment, Charlie, is that the solicitor was out of line preparing a separate decision, and that if, when they saw the decision he prepared for the flat roof, somebody changed their mind and said, you know what, this decision doesn't work for me, I'm willing to go to a pitched roof, then they would have had a timing problem getting a final decision approved before there would have been automatic right on the part of the applicant to go ahead with the project without the planning board having made a timely decision.
Well, I have an issue that the schedule was driving his decision making also. That's another overlying issue that the board was in. I'm not sure why they should have been in that position, but people were, it was geared towards getting something approved, so that it wasn't approved by default. There wasn't a lot of discussion about denying it.
Okay. Well, but I mean, if you read the transcripts of the different meetings, there are many members there were members of both boards that wanted to approve something for that location. Okay. So they weren't thinking of denying the project, they were thinking of tuning up the project in a way that would, in each board or commission's view, be appropriate for that location. It didn't appear that there was a majority who felt like they should deny the project completely. It was just about, well, what is it that we're approving? So, I mean, I do understand what you're saying, which is that, it was, there is a question as to why the solicitor went ahead and prepared two decisions when he had been directed, clearly directed by the straw vote to do one thing for the Historic District Commission and something different for the planning board. But if the planning board changed its mind, they had a time constraint that the Historic District Commission didn't have the same time constraint, just like we don't have that kind of a time constraint.
Mr. Chairman, they had already voted.
Straw vote.
Right,
Straw.
right.
Okay. But that's only two of us, and the thoughts that want to add into the stew here about this question here of the solicitors preparing two decisions when they're coming forward on the July 12th. It's an assignment of error. What do you think?
I don't think anyone feels comfortable on this board with two decisions. This board, I don't believe, would consider two separate decisions, especially with the question of height. With the zoning board and the planning board are two separate jobs. And so we're not discussing, in this case, how we would handle this decision. We'd be discussing how the planning board would handle this decision. Because we could very well say that neither roof were acceptable if this was sitting before us as a board of relief. So, do I have an issue with it? Yes. Do I think at some point from our perspective, as a board of appeal, I can understand the urgency to have an approval or a denial. I do get the sense that there was a push towards figuring out a way to get this done. And I do think Mr. Tice understood that when he was drafting these two decisions. Again, from the perspective of the planning board, can we say that it was a true error? If anybody wants to chime in. Charlie? Well,
If Mr. Chair, at your convenience, I do have a comment that would be helpful, but I don't want to interrupt Charlie.
Why don't you give us your thoughts, Mr. Haddon?
Just quickly, last time on this particular topic, there were conversations and arguments by the appellant that they did not, and Mr. Tice did this on his own, they did not receive copies of these draft decisions. And I believe you're already aware that Diane Williamson on July 10, 2 days before the July 12 hearing, did in fact email to the board the draft decisions and to Mr. McGilvray. I had asked Mr. McGilvray at the last meeting if he would stipulate that he did receive them ahead of time, because he argued that he never saw them. But the email...
That's simply incorrect. I think correct.
It's not incorrect, Mr. McGilvray.
It's not the argument.
But the email did reach Mr. McGilvray on July 10 of the planning board decision, flat roof, planning board decision, pitched roof, and the draft HDC decision. So all three of those decisions were sent to council of record and to the board.
So if the, see, I regard what happened on June 21st as a straw vote. That's what they said it was, a straw vote. It was not a final vote. It was going to be a final vote and a final meeting at which they could again discuss the matter and review the draft decision, not decisions, drafted by their solicitor at their direction. That's what they voted on. They direct voted to direct the solicitor to prepare a certain style of decision. And had the discussion proceeded with only one decision draft in front of them, the flat roof version, and the board changed its mind as a result of conversation or persuasion by the Historic District Commission, then in order to meet the timetable, Mr. Tights would have had to go back to his office before midnight and prepare a decision and somehow reconvene the board or bring his laptop with him. And I'm not sure why he felt it was wise to have alternative decisions, but his preparing alternative decisions is not what caused the planning board to change the vote. They had a discussion, and that's as a result of that discussion, as minimal as it was, on July 12th, they voted formally and finally in favor of approving the peaked roof or pitched roof design. And he happened to have a draft decision for them to execute and approve at that time. So I don't see that there is prejudicial procedural error, because had they had the one version, flat roof version in front of them, and they changed their mind, then maybe he would have had to cross things out in order to have a decision in front of them that they could approve that night. But I think he prepared to. So I don't think it's prejudicial. I don't think it affects the outcome of the matter, because if the board changed its mind as a result of its deliberations, albeit in a joint meeting with the Historic District Commission, there was a way they could have modified the flat roof decision into a peaked roof decision that night. And the fact that he prepared for backup, I don't think it's prejudicial. I don't think it's prejudicial.
So if the flat roof was the only option that was offered for the June meeting, and they voted to approve it, and the HDC voted to approve the peak roof, it would have had to be reconciled.
And they reconciled it on June 12th. That's what they did. They reconciled.
On the 12th meeting, they knew they were in opposition with the HDC. HDC had already said they wanted to
I will
approve
vote that.
And so at that point, Mr. Tice, he decided to give it two. And it's not the height. Both heights exceed the zoning. That's going to be our problem. It was the view. Which one looked better? And they voted on which one looked better on the 12th.
Which is more the purview of the Historic District Commission.
Exactly. Why the Historic Division was going for pitched roofs. And if they had, where would they be on the 12th if they didn't have?
They would have had to adjudicate it, which was what was discussed in
Which
June.
what was done.
No, it wasn't adjudicated.
There was
way that it was
discussion
described.
on the 12th on the pitched roof.
It wasn't adjudicated the way that it was described in the June meeting.
Well, the June meeting mentioned it would have to be reconciled. They reconciled it on July 12th. They chose to reconcile it then and there by at least one member coming over to the peak roof design. There were some members who were going to vote against any of it because of its height. And they weren't, their minds didn't change. So the design, matter, somebody changed his mind. That was a way to reconcile these two inconsistent straw vote decisions, not final decisions, straw vote decisions. So they reconciled it on June 12th. I don't know if I was the solicitor that I would have prepared it two ways only for one board. I might have prepared it two ways for both boards in the event that the reconciliation went the other way, where the planning board members' discussion somehow persuaded the Historic District Commission to go along with the flat roof.
was 4-1, there were between decisions. If it was 4-1, so if it was 4-1, what's the baseline? If it was 4-1 in favor of the flat roof, would there be a second decision written in case two people changed their mind?
But I thought it was 3-2 on the
It was.
straw.
I'm just suggesting is that how we manage voting? Well, it was only 3-2, so I'll do 2. I think we're ready for a vote.
Yes, I think.
Okay, we're ready for a vote. Well, I'm going to make a motion, maybe it won't be unanimous this time, but I'm going to make a motion that the assignment of error in paragraph 1E with regard to the town solicitor drafting findings that were inconsistent with the straw vote amounts to prejudicial procedural error. I'm going to make a motion that we deny that assignment of error. Is there a second? Okay, all in favor of denying the assignment of error in paragraph 1E? Aye. Aye. All opposed?
Nay.
Okay, so 4-1. A vote of 4-1. That assignment of error is denied. The next assignment of error is in 1F. The Planning Board is required to make recommendations to the Planning Board regarding any variances required and whether they should be granted. The Planning Board was instructed by the town solicitor that it could not consider the applicable standards for granting the variances in making these recommendations. This is clear error. I'm not sure in reading the decision that was approved by the Planning Board that they made any recommendations with regard to the variances. I don't see them making any recommendations to this board when and if we have to sit as a board of review with regard to petitions for dimensional variances for this project. I mean, there is a discussion in the decision, and there was certainly were discussions in the various meetings, including the meetings of June 21st and July 12th, with regard to the number and nature of the variances that would be required, but I do not see a recommendation in here about any of those. There's commentary that most of them are minor or technical in nature, but that does not, to me, amount to a recommendation. There is a recognition in the decision of the Planning Board that the proposed development is not in compliance with the standards and provisions of the zoning ordinance, and that were it to proceed ahead, it would have to get variances, but they don't make any recommendation. I don't see any recommendation in this. The assignment of error is that the Planning Board was instructed by the town solicitor it could not consider the applicable standards for granting the variances and making these recommendations. I'm not sure I saw that in the transcript. It may in fact be there. But if the solicitor said it's not your job to decide whether there's a hardship that amounts to more than mere inconvenience, whether that doesn't trouble me if that's what the solicitor told the Planning Board, is the Zoning Board has its responsibilities and you have your responsibilities. So if the assignment of error is there was some improper advice by the solicitor, I don't think that amounts to improper advice to say the Zoning Board has a different function and they have different standards. You have to look at your standards, they'll look at their standards. That, to me, doesn't amount to an error. The allegation of error, the particularly focuses on the instruction by the town solicitor. So I don't think the instruction from the town solicitor that we have different standards than they have, and that they have to address their standards in making their decision amounts to error. Anybody else? No? No? Yes?
I think that the planning, well, it says they need to check to ensure it's compliant with the zoning ordinances. And
They
it's
did
not,
check.
it's not going to be compliant, which is what they said, and it'll never be compliant. It'll be legal, but it will be compliant with guidelines. So I would like to see, assuming that the variances are in the best interest of the town.
I mean, ultimately, that's our responsibility, and there are many cases in which we do not get recommendations from the planning board, and we're still able to make our own decisions about whether the standards for granting or denying the dimensional variance are satisfied. So I wouldn't remand it because I'm not sure it would be all that influential on to me as to whatever the planning board said. I'm not sure that would be particularly influential. Because I think we have an independent responsibility, which is in fact the advice that the planning board was given by the town solicitor, that we have our standards, they have their standards. So, and I think it may be that the assignment of error might have been styled. The failure to make recommendations is prejudicial procedural error, as opposed to focusing on the advice of the solicitor. Because I think the advice of the solicitor, as I read it, was correct. The failure of it might be error. I don't think it's prejudicial error, because we're going to make when and if the petitions for dimensional variances get to us, we'll have to make our own decisions. So I don't think it's prejudicial. That what they wrote about the variances, identifying what variances would be needed, saying it's not in compliance, and their commentary, which I don't agree with, that the variances are minor or technical in nature. I don't agree with that, but it's still not prejudicial error because we have an independent function to perform. So, I'm ready to vote. Okay, I'm going to make a motion that the assignment of error alleged in paragraph 1F be denied for the reason that although the planning board didn't really make recommendations, it only identified the variances required, that the instruction by the town solicitor that the planning board had to consider its own standards, and the zoning board has different standards, does not amount to prejudicial procedural error. All those in favor of denying say aye. I didn't ask for a second. So is there a second to my motion?
Second.
Okay, now I'm going to ask all in favor of denying say aye.
Aye.
Aye. Any opposed? Okay, so 1F is denied. 1G, there's an assignment of error, prejudicial procedural error, that the planning board was improperly instructed by the solicitor that the proposed rooftop access structures, enclosed stairways, and storage areas are to be excluded from building height calculations under the zoning ordinance. I think that's our domain and not the planning board's domain. Whether we agree or don't agree as to what the proposed height is when we're presented with a petition for dimensional relief on the height of the building is up to us to decide what is and what is not counts for the height that we regard. So I don't think this is prejudicial error, even if it is error. I don't know whether it's error or not, might be, but I don't think it's prejudicial because ultimately, you know, the project is not going to get built unless they get dimensional relief from this board, and that's up to us to make that decision when and if it gets to us. So do you have anything to say on this one? I'm going to make a motion that the assignment of error alleged in paragraph 1G, that the planning board was improperly instructed by the solicitor about height with regard to the zoning ordinance be denied because the decision about the granting of variances with respect to building height is within the purview of the zoning board and not the planning board. So that's my motion. Is there a second? Okay, all those in favor of denying the assignment of error in paragraph 1G, say aye. Aye. Any opposed? Okay. Now we move on to assignments of error with regard to unsupported findings and alleged clear errors of fact and law. And assignment of error 2A as subparts. A lot of subparts. Guessing, Mr. Haddon, you think we should go through each of those consistent with our process so far, or not? There you go. You make for a long night. Okay, so 2A.
I don't think it's necessary to, I mean, you're referring to the page, we know what page it is. I don't think you need to read every part of it.
But each of the sub ones, the little i's and the little two
Yeah,
i's.
just maybe a key word on each and how they go together.
All right, so the main part of 2A is that the project is not consistent with the comprehensive plan, and there is no competent evidence on the record to support a finding that it is. That's the main assignment of error. And then there are examples that the appellants identify as evidence of the inconsistency between the project and the comprehensive plan. And those examples, there are 9 of them, the first of which has to do with the comprehensive plan's overall vision about Bristol being an exceptional small town historic character, and that the design to be approved by the planning board would have to be consistent with the comprehensive community plan for the town of Bristol. So this has to do with historic resources and the connection of the town to the water and its long history. So with respect to 2A little I, I think this is subjective. You know, that criteria is subjective, and it's sort of subjective determination by the planning board that the project is consistent with the comprehensive plan. Although there certainly was evidence presented that it was not consistent with the comprehensive plan, there was evidence presented that it was consistent with the comprehensive plan. This is a subjective determination, and we were instructed by the attorneys that it's not our job to second guess the judgment of the planning board, and that we might not have decided this the same way, but if there is evidence, as Mr. Tights was wont to tell us, more than a mere scintilla of evidence, doesn't have to arise to preponderance, but we're not supposed to upset or reverse the decision of the planning board. And I think most of these criteria in here, the record does have evidence presented in favor and against the question of whether aspects of the comprehensive plan would be inconsistent with the project. But all of these, I think, are within, at least certainly that first one is within, I believe, the subjective judgment of the planning board as to whether it's consistent on the vision expressed in the beginning of the comprehensive plan. That's in that one.
There were a lot of zoning board decisions where you will have to decide.
I grouped that. I said we could probably address those as well when we get to them.
So, well, I'm not, we have been doing them one subparagraph at a time, but I'm just looking at these and saying, my take on it, just my take on it is little two eyes is the same. Yes, there's a broad goal that the town of Bristol shall respect and reflect its historic character and the association of bays and harbors. And there was experts who felt that from a historic standpoint, this project was inconsistent, and then there were experts and testimony and argument that it was consistent with historic character. So that, again, little two eyes to me is the same. Subjective determination, whether we would have reached that conclusion, it's not our right to go back and second guess them if there is sufficient evidence, and that's enough evidence to be more than a mere scintilla. And I think 3 is the same with regard to historic resources, linking Bristol's present with the past. There was testimony by their architect that they worked hard at a design that looked like separate buildings, and the materials that they're choosing and the design is historic-ish. That's there. Isn't that the domain of the planning board to make those decisions, and not up to us with regard to consistency with the comprehensive plan?
My feeling is the first 4 are subjective, and the rest, except for 9, are zoning board decisions.
We can't hear you.
What I said is, I believe the first 4 are subjective, and the next 5, or the next 4 are zoning board, where the last one is the statement on FEMA.
FEMA, F-E-M-A, FEMA. So are you suggesting that we deal with little I through little IV?
Yes, exactly.
As a group? Okay, so all of those are with respect to the general policy of promoting certain land use patterns that are sensitive to the town's characters and assets, the goal that it respect and reflect historic character, and that the land use objective be to maintain historic district protection. Those first 4 instances or examples of the assignment of error in 2A being the project is not consistent with the comprehensive plan. My take on little I, but Mr. Kern's take on little I through little IV is that they are all within the subjective judgment, that there was evidence both ways presented to the planning board sufficient evidence under the standard of more than a mere scintilla, although less than a preponderance of the evidence, and that was their subjective judgment, and it's not up to us to second guess that or reverse on that basis for those first four. Right? Okay? So I'm going to make a motion that the assignments of error in 2A, little I, little 2 I's, little 3 I's, and little IV be denied, that there is in fact sufficient evidence to support those findings. They do not amount to clear errors of fact and law for the board to have concluded that the project was consistent enough with the comprehensive plan, because that was their responsibility to make that subjective judgment, and it's not up to us to reverse them as long as there is sufficient evidence in the record. And I'm going to make a motion that there is, and that we find that, and that we deny the appeal as assigned error in 2A, little I through little IV. That's my motion. All those in favor say aye. Aye. Any opposed say nay. There are no nays. Now, Mr. Curran, you were saying that the next 3 assignments or instances that are raised as assignments of error with regard to zoning requirements and standards in the zoning ordinance which would require the applicant before the planning board to come before the zoning board for relief with respect to density, height, and lot coverage are matters that if the planning board was approving it, would not bind this board and would be merely recommendations. But they didn't amount to recommendations because they said it's not in compliance, and that's going to be up to the zoning board to make those decisions. So, although the planning board recognized that the height and the density and the lot coverage were not in compliance, that it would not be prejudicial error procedure, or it would not be, here it's a question of is it a clear error of law or fact, because there is sufficient evidence in the record that they didn't comply. There's no argument about that the plan does not comply with the requirements of the zoning board, or the zoning code does not comply, in connection with height, lot coverage, and density, and in fact 12 other areas, because the planning board identified 15 variances that would be required for the project to proceed as presented. But on those 3 assignments of error, there isn't an error on, as I understand the conversation, there's not an error because they recognized it was not in compliance with the zoning ordinance. And I think the allegation of error is that makes it inconsistent with the comprehensive plan, and therefore the board should not have approved it. And there isn't sufficient evidence in the record. I think the evidence in the record is it did not comply. But they recognized that these are issues for the zoning board to address when and if the applicant presents a petition for relief to the zoning board at some appropriate future point in time. So on that basis, I guess I am prepared to make a motion, but does anybody else want to say anything before I make a motion? On those 3 examples of an assignment of error of inconsistency with the comprehensive plan. Okay, if not, on those three, I'm going to make a motion that we deny the assignments of error in 2A, little v, little vi, and little vii. You included,
That was a mistake.
okay. All right, so those three, I'm going to make a motion that you grant that assignment for error be denied as not amounting to a clear error of fact or law, and that the finding is in fact supported by sufficient evidence in the record, because those findings recognize that the project is not currently in compliance, and that if it's going to proceed, it will have to get relief from the zoning board. All the planning board did was recognize the areas of nonconformity with the zoning requirements. They identified that, so the record has sufficient support that they identified that the plan as presented didn't conform. But that doesn't necessarily mean that it was a clear error of law to say that it doesn't meet the overall requirement of the comprehensive plan, because the zoning board has authority to either grant or deny relief in the future with regard to density, height, and lot coverage. So for that reason, I move that we deny those assignments of error. Is there a second? All those in favor of denying the appeal on those grounds, say aye. Aye. Okay, any opposed? Okay, the next two have to do with the FEMA regulations. Don, what about those FEMA stuff? Talking to the microphone.
I don't know what to do with these two.
Well, the first one, I didn't think there was anything in the record that said that it was 35 feet, that the record that there were many references throughout the record that because of the FEMA requirements that they got a 1 foot, they get a 1 foot bump. That seemed to be consistently throughout. So I guess the allegation of error in little v triple I, so little a there, that one is the applicant claimed the FEMA regulations require the building height to exceed Bristol's 35-foot height limit. That is not true. According to the zoning ordinance for new construction, in lieu of being elevated, non-residential structure may be dry flood proofed to 1 foot. So I guess this assignment of error in little a is that exceeding the height limitation, the normal height limitation, is not the only way to satisfy FEMA requirements. The FEMA requirements could have been satisfied by building at the 35-foot, or building up to the 35-foot height by dry flood proofing the first floor.
But again, there are options to either go above the zoning height or do something lower down. And I don't see where this is a prejudicial error at all, in that they chose to exceed the zoning height. I don't see an error here at all.
I mean, just the way...
They may say that the new state that FEMA requires them to go to 35 feet, but I don't think that's prejudicial.
Right, and the next one, little 9, little ix. That one also, the allegation of error is that the applicant made a certain claim. Well, it's not error for the applicant to make whatever claims they're going to make. The question is, did the board make an error? And that's really the question, is did the planning board err in approving the project, using 36 feet as its benchmark, right? As opposed to 35 feet, the 1 foot because of the FEMA flood zone elevation map or whatever. So I don't know how they made that claim, the applicant made the claim, whether the claim was accurate or inaccurate, the question is, did the board make an error in approving the project?
And the board did consider these.
They did consider. So if the board considered them, and they had to address flood requirements, they addressed flood requirements. So they're addressing flood requirements. I take your argument or your analysis, Mr. Kern, to be that they addressed it, and they addressed the FEMA requirements. They were required to do that. They did. They accepted the notion that 36 feet would be a permissible approach under FEMA by giving them a 1 foot bump because of the elevation at the base level.
They're still going to exceed the 36 feet.
And they're still going to exceed the 36 feet. I'm good at reading that back. Okay, so with respect to 8 and 9, your take is it's not a clear error of fact or law. Right. And if it is, it's not the board's error, it's the applicant's error. Okay? Okay? All right. I'm going to make a motion that we deny the instances of assignment of error in the appeal paragraph 2A, little VII and little IX, having to do with FEMA regulations. The assignment of error is the applicant made certain claims. If the applicant made those claims, the question was whether the board took FEMA requirements into consideration in its approval. The record is very clear. They did address the FEMA requirements for new construction as they were required to do, and that is not a clear error of fact or law so to do. For that reason, I move that we deny those particular assignments of error. Is there a second? Second. All in favor of denying those assignments of error, say aye. Aye. Okay, any opposed? Okay. Assignment of error 2B. The project is not consistent with the zoning ordinance to the extent that 15 variances are sought for one partially developed lot.
Should we just vote on
I think Mr. Haddon will tell us we're supposed to have some discussion of that. But that is clearly up to this board to make a determination as to whether relief should or should not be granted. That's why there's a zoning board of relief. We have not yet reached that point in this project's history. The planning board recognized that the project as presented did not conform to the certain dimensional requirements in the zoning ordinance. So that is not an error of fact or law to recognize that there was nonconformity of that, and to also recognize that the zoning board would have to have its opportunity to make its own determination. So for that reason, I move that we deny assignment of error 2B. Second. All in favor, say aye. Aye. Any opposed? Assignment of error 2B is denied. Assignment of error 2C. Planning board ignored compelling and overwhelming expert evidence that the scale, mass, and design of the project are inconsistent with the purposes of the subdivision and development review regulations. Member Anthony Murgo expressly rejected the expert testimony, stating to the joint boards that the experts maybe have something personal against the developer. And then there are examples of that. Project is not of appropriate design and construction. Project does not protect existing natural and built environment and offers no mitigation of significant negative impacts on the existing environment. Project is not well integrated into the surrounding neighborhoods with regard to natural and built features. The site and its surrounding neighborhood cannot support such intense development because of the density of the built environment and its lack of existing infrastructure such as on-street and off-street public parking and traffic. Project ignores the intent of the comprehensive plan with regard to physical character of the neighborhood. Project will damage the critical historical landscape and architectural and cultural resources of the immediate neighborhood. So this area is in the lane. There's a lot of discussion these days about being in somebody else's lane in connection with the Second Amendment and gun safety matters, but this is in the same lane as our prior appeal with regard to the Historic District Commission about how expert testimony and evidence was handled by the Planning Board and the Historic District Commission. And it's my recollection that we found the record and the decision of the Historic District Commission wanting in its treatment of expert evidence about historic preservation, historic nature of the development, and remanded it for that reason. I'm not sure it's the same with the Planning Board. I'm not sure. One of the criteria that was addressed in the Planning Board's decision would be paragraph 2E of the Planning Board's findings of fact and conclusions of law, which I think is largely what the Planning Board says in its decision that reflects it all on the aspects in assignment of error 2C. So the Planning Board's decision says the project's massing and scale proportionally mirrors the surrounding historical patterns and will not alter the general character of the surrounding area. Finding of fact and conclusion of law number 4, that's the one that deals with the height of the building and the surrounding buildings and the mercantile building business. So there's something in the Planning Board's decision about the expert, at least the subject matter that the expert testimony addressed. Now, I asked during the argument, let me just finish and I'm done. I asked during argument about finding 2E, which is presented as finding of fact and or conclusion of law about proportional mirroring, and that there was nothing that I found in the record where the planning board identified the surrounding historical patterns particularly. There certainly was evidence, expert information, evidence, testimony, and exhibits, pro and con on that. But the planning board didn't make specific findings. I know we remanded to the Historic District Commission for this very reason, that we found it impossible to review whether the finding and conclusion was supported by the weight of the evidence. I don't know whether that's the appropriate approach here. I'd be interested in hearing what other people.
Again, this is subjective, this part here. And I question whether this is in the purview, really, of the planning board, and more in the purview of HDC, which we did remand back to them, give us evidence. And I haven't seen the results of that yet. But I mean, there's plenty of discussion during the open meetings, both mostly common. This didn't meet the comprehensive point. But there was discussion, and on both sides, whether you agree. I mean, the disagreement that the HDC had was that the experts on the applicant were not historical experts. They had architects, they had technical, they had engineers, which I think is more in the purview of the planning board, which expert to consider. And they considered both experts. They apparently gave low credence to the historical side of it. But that's their decision, not ours. You know, did they consider it? And is it, really, was it in their purview or was it in the HDC's purview?
Well, I took the appeal to be focused on that the planning board didn't really discuss any of the expert testimony. You know, they didn't discuss it at all with regard to the historic aspects of the project.
But they did listen to it.
Yes, they listened to all of it, and they accepted documentary evidence as well. Both boards did. I'm not suggesting we have to be consistent in both decisions and also remand this back. That's what we did because it was clear that the Historic District Commission had primary responsibility for the historic impact. That's their primary. That was in their primary functional responsibility. And while massing and scale are aspects in the planning board's subdivision and development regulations, not in the context of the historic aspects of it. It was about whether massing and scale will adversely impact the surrounding area, not so much focused on the historic aspect of it. And while there were expert opinions and testimony and documents submitted on both sides of it, I take your argument or your analysis to be that this was their subjective judgment and there was some evidence in the record, and it wouldn't amount to clear error of fact or law for them to conclude it this way, even if we might not have reached the same conclusion.
That's what I said. Reword.
One thing is, they say this building doesn't fit in the area, but if you look a little further down, Thames Street, Langdon, the Bristol, what is it, the Harbor Inn, that's a large building there.
But that isn't our decision. The decision
Yeah.
that we have here
I mean,
is
there are,
whether
yeah.
or not they considered it, in this case, whether it was considered
Yeah.
or not. And, you know, back because we don't agree with their decision. Did they consider the evidence? And I suggest in their purview of the planning board, not the HDC, they have different charters.
There was an outstanding question from the last meeting. And, it was with regard to this chart, pictorial, surrogate-with comparison to subject proposal. And you know that, is this what was used? Is evidence itself?
It was a large version of that. I believe that's a photograph. It was presented on a poster board.
Is this the chart that the planning board used to make the decision?
Well, it was presented to the planning board as part of the record.
It's part of the record, sure.
And I at least took it the way you presented it to us. It was part of their application, because it was stapled. The version we got, that reduced photo thing was stapled onto what I got.
I think that was submitted by neighbors.
Okay.
That was submitted by
So it's-
the opposition.
Okay, so that's an exhibit that came in
That's correct.
during the proceedings.
We have the original in the office. That's a photograph. That was just for purposes of putting it on.
Maybe I assembled it incorrectly.
And
There was other diagrams done by the applicant, which showed individual buildings in the surrounding area.
So the assignment of error, I mean, I know there were instances, but the assignment of error is the planning board ignored compelling and overwhelming expert evidence that the scale, mass, and design of the project are inconsistent with the purposes of the subdivision and development review regulations. So the assignment of error is they ignored overwhelming and compelling expert evidence of scale, mass, and design being inconsistent with the regulations. And then these are all instances of regulation issues which the appellants believe were violated, I guess, by the approval of the plan. And this turns on the question of there was conflicting expert evidence. There was evidence in favor of and evidence against the scale, mass, and design of the project meeting the requirements of the subdivision and development review regulations. So is that clear error of law or lack of sufficient evidence in the record? Mr. Kern believes these aspects, or the specific aspects, are subjective, and that the planning board must have felt there was sufficient expert evidence to support the finding that was articulated in 2E of the decision, that the mass and scale proportionally mirrors surrounding historical patterns and will not alter the general character of the surrounding area. I would have liked that finding to identify what those historical patterns were and how this was consistent with them, or proportionally mirrored them. Because I read that finding as a mere conclusion, not a finding of fact, but it is their conclusion that it won't alter the general character of the surrounding area, and that it is so. ahead on this?
It's very difficult for us to determine what people were thinking. So, based on that, I wouldn't have a basis to determine if there was an error.
Could you speak up, please?
Sure. I wouldn't be able to determine that there was an error based on the evidence.
That means you would deny, the thing is to deny the appeal on that ground.
My opinion is that I really can't uphold this applicant, but it's between remand and the denial. And the denial.
So you would not reverse
I will not.
on that ground.
On that ground. Now, my question is, it's not right. I would deny it myself. But I think this board has to decide whether or not there was sufficient evidence in the planning board's purview to determine did they see it. I mean, I just went through, there was two sets of buildings, one by the applicant and one sent by the opponents. And both were considered, both went to the board. And whether or not there was a lot of discussion on it, and there was definitely a lot of discussion by the public on it, which they had to listen to. And it's up, I mean, I make up my mind in my head, and I don't have to discuss with too many people what my decision is. So whether it's in the record, they had the evidence, they heard the public, and they made a decision.
So if I understand what you're suggesting, Ron, is on the aspect of clear error of fact in law, that's within their subjective judgment as to whether or not this massing and scale is proportionate or not proportionate with the historic character. That we wouldn't be able, on the clear error side. So where you're trying to figure it out is on the, is there a decision sufficiently supported by the weight of the evidence? And when we had a similar concern in the Historic District Commission, we said we can't figure this out because you didn't weigh the evidence and you didn't tell us about it. But there, it was more criteria that had to do with historic aspects.
Right. And there's two aspects of the comprehensive plan. There's a historic aspect and there's a growth aspect to the comprehensive plan.
And there's a land use
And
aspect.
there's a land use.
Growth aspect, land use aspect, and historic aspect.
Right. And so historic is only one item.
So if there was evidence in the record, one chart presented to the board that demonstrated buildings that were proportionally consistent, and another chart, Exhibit T, presented by the opponents at that hearing, and the board reached the conclusion they reached in paragraph 2E that it mirrors the surrounding historic patterns, that they had evidence, two different kinds of evidence. So if they had evidence and they credited one, as they apparently did by reaching a particular conclusion, then that evidence was more than a mere scintilla. It was a chart,
lot.
a consistent, a complex, professionally prepared chart or charts, which were put up against a different professionally prepared chart, and pictures and building heights and comparisons. And the board appears to have credited one and not have been influenced by the other. And if that's the case, then their decision was supported by some record evidence.
There was record evidence on both sides.
And that would mean you wouldn't grant the appeal. You guys are? Okay. Tony, you there?
No, I think that,
You know, when we had the conversation, a couple of times, you brought up the reference to a non-existent building.
that I believe stopped existing in 1937. So I don't feel that that would be a reference point for this particular project. What I do feel is that the planning board was focused on height and evidence that they saw in relation to mass and scale, either for or against, wasn't, in my opinion, their focus. So they did receive information that would have given them grounds to approve. Again, my personal respect of the information, that aside, I do think that they were given good information. But again, to reference buildings that no longer exist, we can reference a lot of things that no longer exist. It doesn't necessarily give them grounds. But I do think that they were given an opportunity to make a decision, and they received for and against, and apparently been read as heavily as I think it
Well,
We're going to get our wrong.
okay, well, listening to that discussion, I will make a motion that the assignment of error in paragraph 2C of the appeal, that the planning board ignored compelling and overwhelming expert evidence that the scale, mass, and design of the project are inconsistent with the purposes of the subdivision and development review regulations, be denied. There was a lot of evidence, pro and con. There may have been more evidence presented by the objectors' experts than there was evidence presented by the applicant's experts, but there was sufficient evidence, because it was more than a mere scintilla, and it was not clear error of fact or law to reach the subjective conclusions that the board reached about compliance with the subdivision and development review regulations. So I'm going to move that we deny the appeal with regard to the assignments of error in paragraph 2C. Is there a second?
Second.
All those in favor say aye. Aye. Anyone opposed? The assignment of error in 2C is denied. The last assignment of error is that the planning board improperly ignored the potential archaeological significance of the southeast corner of the subject parcel, despite significant archaeological and cultural resources found elsewhere on the site, by not requesting further investigation of the area not previously investigated in derogation of subdivision and development review regulations This was not a point that was argued by anybody to this board, the archaeological aspects. We didn't hear anything about it.
I thought the evidence showed, there was a finding with the evidence, I believe, that showed that the project would not affect the archaeological value of the site.
I believe that there was an archaeological study that was done, and whatever distillery or rum manufacturing that had occurred in that area didn't reach their proposed project.
So I think it had been addressed, was my note.
Well, is there anything in the decision about the archaeological and cultural aspects? Because that is something in
Yes.
the regulations. So where in the decision does it address? I don't see it in the decision, and I don't believe it was discussed in the deliberations of the planning board. It certainly wasn't discussed on July 12th, and I don't think it was discussed on June 21st, reading the transcripts. The assignment of error is they ignored the archaeological significance. And the appellee's memorandum in support of objection
Do you have the, I don't have the,
what?
because I believe there was a file in there, and I believe there was a letter.
There was a letter at some point from, and the study was cited, and I don't know if it was in the rebuttal to the appeal or actually presented during any of the meetings. But I did see that an architectural study archaeological study was completed, and there was nothing significant being found to deny a building being put there of any kind.
So we have this assignment of error about archaeological significance that the board didn't do enough. They should have requested a further investigation, but the record does include the report of some archaeological investigation with regard to a prior brewery site or something like that. distillery site. So there certainly was some evidence in the record that had been submitted about an archaeological inquiry or investigation. So, and this is not something that was presented in argument to this board other than in the appeal document. So I'm not saying it's, and it is certainly the case that Mr. McGillivray did not waive anything that was in his appeal when he appeared and made his oral argument remarks. And Mr. Kelly didn't waive anything, but he didn't address archaeology either. So we were not assisted in any way by either counsel at the argument date in October. So the fact that the board had some archaeological evidence presented to it in the record meant that they at least addressed subdivision and development review regulation that said they were supposed to take archaeological and cultural resources into account in considering development plans and proposals. So would that amount to clear error of law or fact? I don't believe it would amount to clear error of law or fact because they considered it. It was presented and they had it as a part of the record. Is the decision supported by the weight of the evidence when the decision doesn't address that particular factor at all? The written decision doesn't address and recite that there will not be negative archaeological or cultural impacts as a result of this project. So that's kind of what, maybe that they should have said that. So Mark, do you have any guidance for us on this particular aspect of the appeal?
I do. Obviously below, this was a non-controversial issue. The reports were submitted, the information was provided, the board required, or the planner required that this be part of the application, and therefore that's part of what they considered. There was no countervailing report. I just checked that with...
There was no what?
There was no countervailing report that said that there was an issue.
Right.
And I mean, there are a lot of things in a decision that aren't specifically going to be mentioned about every aspect of the application. What's signed here and what's signed there. And I think this falls within those issues that were non-controversial. The board was satisfied with what was provided to them. The applicant, the appellants, I should say, excuse me, did not disagree, did not even do their own report. And the question is whether this decision, which permits the matter to go forward, is appropriate. And it's, as a matter of law, where there's no controversy, it is. If there was a controversy, there would have been a lot of argument on it. We had a lot of argument on a lot of issues, and that never rose once in the hours that we discussed it. And apparently, there wasn't a lot of time spent on it below once the report came and provided the information that there wasn't an archaeological problem. There was no countervailing evidence, so they could only reach one conclusion at that point. And therefore, that, among, I'm sure, other things that somebody could pick out of a hat that was not mentioned in the decision, is not an essential part to be necessarily included in the decision.
Okay. Anybody want to say anything else? Okay, I'm going to make a motion that the assignment of error in paragraph 2D, that the planning board improperly ignored potential archaeological or archaeological significance or cultural resources be denied. The applicant at the planning board proceedings presented an archaeological report. There was no countervailing report presented by the objectors. That matter was not the subject of any significant, in fact, doesn't look like it was the subject of any deliberation or discussion at the planning board. did not appear to warrant further investigation, since the report concluded that it would not have been detrimental to archaeological or cultural resources. So for those reasons, I move that we deny the assignment of error in paragraph 2D.
I'll second
All those in favor of the motion? Aye. Anybody opposed? Those are the assignments of error that have been presented to the board. It's my recollection from the hearing tonight that we've denied every one of the assignments of error. And Mr. Haddon, are you able to prepare a written decision for us based on our oral deliberations this evening?
I am.
Okay, so would we have to continue this matter to another date certain for us to have the opportunity to review that decision and then
Yes.
approve it?
I'm sorry, Ed was speaking with me as well. Yeah, I do recommend that I put something in writing, and that you review it a couple days beforehand. You're free to respond to me individually with comments, but not share them. So you make sure that whatever you send to me is not copied to anybody else, or reply all, any of that. And I'm happy to reply to each one individually and any comments that you have. And once we come here, then those comments can be shared in the open meeting.
Okay, so
for example, I just noticed right the moment after you mentioned your decision, there's a general statement that the plan allows for and focuses on the protection of Bristol's historic and cultural values, which that, as you just mentioned in your decision, is often part of what you look for in the archaeological things. And that covers a lot of minutia that's non-controversial. And so there's no need to really say anything more other than, would you like it to be mentioned, I suppose. But it's, where there's only one conclusion that they could draw from the evidence in the record, there's really no need to go any further than what they did, I believe.
So Mr. Haddon, my suggestion is that you do not prepare alternative decisions for us. A single decision for us to review and consider at a date certain in the future. Ed, when would that date certain be?
Well, our next meeting is Monday, December 3rd. Otherwise, it would be January 7th.
Right, well, so that's a week from this evening, I think, or less than a week from this evening.
Right.
So I don't know whether it's possible for Mr. Haddon, do you think you could have that done by the end of this week in order to have that circulated by the end of this week?
Sure, I'll do it.
Mr. Chairman, may I be heard for one moment?
Sure.
With respect to the manner in which we're going to get a final decision.
Come on up, Mr. Resin.
Respectfully, I thank you for all of your time tonight, and we've had a vote denying the basis of every single appealable issue that was raised. I would request that there's a final vote with regard to this appeal in its entirety right now. Now, I understand that this decision may be memorialized in writing, and that essentially any appeal rights would flow from the time that that decision is filed. But ultimately, we have heard the board's decision with respect to every single appealable issue that was raised. And for that reason, I would request that there be a final vote this evening.
The purpose in writing the decision is to make sure it's complete. And if complete, comprehensible, accurate, and by continuing the matter for me to present you with a written decision, as courts have requested counsel do for their boards, it's important that you vote on the final product. Otherwise, what I send out in writing, when you have previously voted on the general aspect of your votes. The argument can be made, and I know Mr. Resnick's office has specifically made this argument, that the written material came later, it's not word for word what was in the transcript, and therefore the written decision is worthless. So the purpose of continuing this for you to make your final vote based upon the written document is important, so that the written document itself is not challenged for being inaccurate, or that me as solicitor somehow improperly influenced you to make a decision that you didn't want to freely make yourself. And that's important to me, that you see that product and you decide, yes, Mr. Solicitor or substitute solicitor, this is what we want. And that this is consistent with how we have decided. And we have to make sure that the decision itself is in good stead under the law, because a judge is going to do, perhaps, potentially, what you just did to their decision. They're going to look at yours too. So we want to make sure that we're complete, we're not missing anything.
So you're not going to have a transcript in 4 days to make a written decision?
No, and that's, you know, that doesn't make it easy.
Okay.
If you prefer, I'd rather prefer January actually, but.
Well, I do take the appellee's point that this matter has been ongoing for some time, and to the extent that you have the capacity to draft a proposed decision for us by the end of this week, I don't think a 1-week delay for us to then have a final vote on that is excessive at all. In fact, the project is not proceeding apace because the Historic District Commission, I don't think they've acted on the remand yet. Thursday night. So if they haven't acted on the remand yet, I don't think a week is a significant delay, despite Mr. Resnick's argument to the contrary. I personally feel like it would be beneficial to us to be able to read your memorialization of what we have voted on tonight and have us have a single final approval vote. Is there anybody who doesn't think that's right on the board? So that's what we're going to request you to do, Mr. Haddon. I think that's all we have for tonight.
We should make a motion to continue.
Okay. So will you make a motion, Mr. Burke?
I will. We going to try to do it on December 3rd, or
We're going to just sit on December 3rd.
I'll make a motion that we continue the hearing of this appeal until December 3rd.
You don't have to advertise that, Ed, do you?
Oh, it'll be added to the agenda. The agenda will be posted. I will amend the agenda that's already been posted to include this, as long as it's 48 hours prior to the meeting.
Okay. All those in favor of the motion to continue this matter to, we had a second. Mr. Simoes seconded, to December 3rd, say aye.
Aye.
Any opposed? Is there a motion to adjourn? I'll make a motion to adjourn. Is there a second? Second. All those in favor of the motion to adjourn? Aye. Any opposed? Thank you.